Hi, I'm Brent Van Dyson. As an elder law attorney, my law firm can help you protect your assets from the high cost of nursing home care. In your community, we will soon be having free legal seminars where you can come and learn more about the options available to protect your home and your life savings from the high cost of nursing home care. Watch your local newspaper for advertisements of this event, or visit our website at wvelderlaw.com for a list of the upcoming seminars.
Welcome to this episode of Legally Speaking. I'm Amy Strobel. I'm here with Brent Van Dyson from the Van Dyson Law Office. Welcome back.
Thanks for having me.
Anytime. We get so much valuable information from you. In our previous episode, we started to touch upon a really kind of difficult topic with home ownership and how to keep your home if you go into nursing care home. And I'd love to just keep going with this because I feel like we have a lot of information to cover and a lot of misinformation we need to get straight.
Absolutely.
So how should we start?
Okay, so I just want to recap what the issue is. I would say the number one concern that I hear people coming to me with is, if I go into a nursing home, I don't want to lose my home. Mm-hmm. So the issue is, in West Virginia, if you go into a nursing home, have spent through your life savings and have now qualified for Medicaid, the Medicaid program in West Virginia will allow you to keep your home so long as you're alive. But at your death, if you're the last owner and occupant of the property, the state has the right to put a lien against the home to recover what Medicaid has paid for your care. Now, the good news is there are many legal options that would allow you to avoid that lien, and that's what I want to cover.
Perfect. All right, so where do we start?
Okay, so I want to start by a general statement because I do hear this from time to time. I come across clients who are just afraid to go into a nursing home for many reasons, but out of fear that they'll lose the home. It's rarely ever too late to save the home.
Perfect. Okay.
So that's something I really want to emphasize. When it comes to protecting the home, there's different ways to approach this. The best result comes when you do planning to protect the home in advance of the 5-year look back when you're generally healthy. And when it comes to protecting the home, protecting it from a Medicaid lien, as I had mentioned, there are, as I said, a lot of rumors and misinformation.
Especially in this day of so much information, social media, you can get a lot of misinformation, which is why it's so vital to make sure you're getting the correct information.
That plus things that general practice attorneys have done for their clients in years past that are no longer good ideas. People have had some experience with that. For example, I might have a client today come to me who's in their 70s and say, I want to put my kids on the deed to my home. When I ask a few questions, I found out that's what mom did.
Sure.
She put me and my siblings on the deed to the home so that if she ever went into a nursing home, the state didn't get it. And that can be a way to protect a home from a Medicaid lien. And the idea there is putting a person onto a deed, especially a younger person, if you're making them a joint tenant with rights of survivorship, giving them this survivorship right. Traditionally, to get that survivorship right, you had to make the person you're adding onto the deed a joint tenant, which means joint owner.
Okay.
So the practice in decades gone by had simply been, hey, mom or dad wants to live in the home for the rest of their life. Let's throw the kids on there, make them joint owners with the survivorship right. when mom or dad passes away, their ownership ends, leaving the rest of the children with their ownership. And if mom or dad went into a nursing home, as long as that arrangement was done 5 years in advance, then they avoided a Medicaid lien.
Okay.
Now, the difficulty or the problem with doing that today, if you give one of your children an ownership interest in your home, if that child goes through a legal or financial crisis, like a divorce,
Yes.
lost their job, has to file bankruptcy, lost their health insurance, and now has a $30,000 unpaid hospital bill, and they're getting sued. If while you're
Yes.
living, you've given ownership in your home
Yep.
to your child or to your children, then you've potentially opened the door to one of their creditors being able to get a judgment against them and then try to satisfy that judgment through your home.
house. Okay.
So bad idea in this day and age, especially when there's a great amount of instability as far as job security, benefit security, things like that. I definitely do not advise to add a child as an owner onto the home.
Okay. What do you advise?
So the best option, in my opinion, is setting up a Medicaid compliant trust agreement.
Okay.
So trust agreements are basically legal agreements. It's a pile of legal paperwork that I can create for a client that allows the client to own assets for their exclusive use and enjoyment during their lifetime, but at their death, the ability to pass those assets to children or other beneficiaries, could be anybody. This arrangement then, by creating this thing called a trust, the trust can essentially own the things that the individual owns, or if we have a married couple, own the things that the married couple owns, so that if, let's say we've got a single person, John Smith, or we've got a married couple, John and Rose Smith, we establish the Smith Family Trust. We're going to change the deed on the home from John and Rose Smith to the Smith Family Trust.
Okay.
Now the trust is the owner. However, John and Rose keep lifetime rights to live there. If they wind up going into a nursing home, qualifying for Medicaid, and the Medicaid program is paid for their care, because the only thing they own is lifetime rights, at their death, what their ownership ends.
Okay.
And when they've both passed away, that leaves the Smith Family Trust as the last surviving owner. And in that case, the state doesn't have the right to put a Medicaid lien against the property. When Mr. and Mrs. Smith have passed away, their trust paperwork says, like a will, who would receive that home. So their trust would end if they have 3 children. Their trust might say, at our death, give our home to our 3 children, and a simple property deed changes that, boom. That's when the children take ownership and not before.
So it sounds actually somewhat simple as long as you have the proper attorney to guide you through it.
Yes.
And by proper, I mean you really need that elder care specialty.
Yes, because there's certainly different types of trust agreements out there to serve different purposes.
Sure.
This type of trust agreement, the drafting of it is very particular. Provisions that you can and can't have in it are very important. When you set up an arrangement like this, remember our 5-year look back. You can't set up a trust agreement today, go into a nursing home tomorrow, and then qualify for Medicaid.
It has to be that 5 years before you need it.
Absolutely. But if you've done something like this, most of my clients who set this up pick the executor, the person who would be executor of their estate, to be the manager of the trust. And in this case, the manager has 2 bosses, mom and dad, Mr. and Mrs. Smith.
Sounds good. Yeah.
And so if their home needed to be sold, not a problem, that could be done. But the oldest child in this case is not an owner of anything until the parents die.
Until they both die.
Just in a management capacity would take charge of that if something needed to be done during their lifetime, like sell the property.
Okay.
But at death, all they have to do, in this case, get a simple property deed, change ownership from the Smith Family Trust to the 3 Smith children. They're done and they've avoided the Medicaid
Wow,
lien.
he made that sound easy. We're going to take a quick break, but I want to talk more about these issues in just a moment. Stay with us.
Hi, I'm Brent Van Dyson. As an elder law attorney, I bring a unique experience to helping you plan your estate. I can help you establish a will, a trust agreement if necessary, and important documents called powers of attorney to help protect you in the event of a disability. Please call my Charleston office at 304-343-3777 for a consultation, or visit us on the web at wvelderlaw.com.
Every day, we're bombarded by more than 5,000 commercial messages. So in the clutter, how do you make your advertising memorable? A4 Media's production team has the knowledge and creativity to craft the right message and cut through that clutter. Whether it's the internet, television, or mobile applications, exciting graphics, high-quality video, professional voiceover, and music all combine to deliver a message that reaches your target audience. A4 Media Production, memorable messages that reach the customers you need.
Welcome back to this episode of Legally Speaking. I'm delighted to be joined by Brent Van Dyson, and we are talking about so many issues that affect our, I was going to say elderly population, but really this affects everybody. We're talking about Medicaid. How are they going about collecting funds, funding nursing homes? What are they doing right? What are they doing wrong? And what's your role in all that?
Okay, so there are many planning options available. I discussed a couple of those planning options that are available proactively. And I want to mention now, what is the state doing with regard to these Medicaid liens and what are they not doing?
Okay.
So as I mentioned, the state has the right for a Medicaid recipient who owns their home. They're the last owner, they're the last occupant with ownership rights. That's a property that's going to pass either through their will or through heirship in the probate process.
Okay.
So during that probate process, the state has the ability to file a claim against the probate estate within the claims period allowed by law. And if they do that, then the lien attaches. The probate estate is not going to be closed until the lien has been satisfied. And but there are many things that the state is not doing.
Okay.
So the practice for at least the past 9 years has been that the state is not filing liens against properties with a fair market value of $50,000 or less. Now, this is to determine that value, they look at what the county assessor says the fair market value
Okay.
is. So, for example, if you wanted to check the fair market value of your home, you could pull out your tax ticket, look at the assessed value. Now,
And it's printed right on there.
it is.
Okay.
Now, there's two values, one that's discounted for the homestead exemption. Take the highest value, divided by 60%, that will get you the full fair market value on the home.
And why divide by 60%?
Because the assessment that's on there is 60% of the fair market value.
Thank you. Okay.
All right. So if you're in a nursing home today or about to go in and your home falls under that limit, then their
Under
current
the 50,000 limit.
yes,
Okay.
their current collection practice is not to collect a Medicaid recovery lien against that home. However, a couple of things about that. The reason why our state collects these Medicaid recovery liens is because that is a condition the federal government places on us as a state
Okay.
in order to receive the federal Medicaid dollars. Here's an interesting point. There is no, what I would say is a de minimis exception. In other words, there's nothing in federal Medicaid law that permits our state to not collect against homes with a value of $50,000 or less. However, this has been a practice that's been in place for a number of years.
A state-issued practice. And
So-
why?
Well, there are a couple of things at play. I believe part of the issue involves a third-party collection agent that's
Okay.
doing the collection.
Okay.
From what I've been told, and it's secondhand information, is that it's not economically valuable
Okay.
for the collection agent to spend their resources to collect. And because our state has contracted this responsibility away, then they're, apparently the federal government is satisfied with that answer.
Okay.
For now, and I imagine this could be something that in the future would change.
Okay.
And so if I'm approaching a client situation, I want to be proactive. I want to take a step or suggest the client take a step that will protect the home if in fact they were to recover a Medicaid lien. Because another issue is they're going to look at the value of that home upon the death of the Medicaid recipient, and if the assessment has increased each year, which often they
Often
do,
do.
they may wind up with a home that today is valued at less than $50,000, but tomorrow may not be.
And that can really open, I mean, if you go above that 50,000, you may not realize that's happened, is what you're saying.
Right.
Okay.
And so that opens up the potential for the recovery of a Medicaid lien. Now, historically, there have been some counties in our state where the vast majority of all homes have a fair market value based on the county assessor's determination at under 50,000.
Sure.
So in some of our poorest counties, there have not been any cases of estate recovery. That again is something that certainly could change. There's another part to this that I want to discuss, which is going to be if you don't take proactive action,
Okay.
take a step to legally avoid the lien, and if a lien is in fact placed and you're faced with recovery, then there are some exceptions from the collection of that lien, and I think we ought to talk about those after the next break.
You are good. I keep saying he could be hosting this show. You know, right, when we need to take breaks, don't you? Because he's right. We do need to take a break, so we'll be back in just a moment to
Okay.
talk about that.
Hi, I'm Brent Van Dyson. As an elder law attorney, I help people protect their assets from the high cost of nursing home care. If you, your spouse, or your parent is in a nursing home today or is about to go into one, please contact my Charleston office for a consultation. You can reach us at 304-343-3777 or on the web at wvelderlaw.com. The Van Dyson Law Office, protecting assets for seniors.
Hey, this is Curtis Fleming with Fly Rod Chronicles. We're out in Northern California. Don't know where we'll be at next week, but tune in Network West Virginia every evening at 7 p.m. and Saturdays at 9 a.m.
Welcome back to this episode of Legally Speaking. Brent, you've brought up so many great points about how to protect your home in West Virginia. Let's talk about what happens. You haven't been proactive you end up with a Medicare lien on your home, is there anything you can do?
Yeah, so after your death, if a Medicaid lien has been placed on your home, your heirs have some potential ways to defend against that lien.
Okay, how do they do that?
Okay, there are two ways to approach this. There are some exemptions that, even though the lien is placed, would allow for its removal.
Okay.
And there are some provisions that, even if the lien is not going to be removed and it's going to be collected, you can reduce.
Okay.
You can reduce the amount of the lien. Let's talk about the exemptions that would allow its removal after it's been placed. If the nursing home patient's spouse lives in the home but doesn't have an ownership interest, they will defer collection on the lien.
Okay, until the death of that spouse?
So that's what the law provides. However, I have never seen in the past 9 years a deferred collection lien
Followed up on.
process.
Wow, okay.
Correct. So by default, what I'm seeing happen is in spouse cases where we have a non-owner spouse in the home, that what the recovery agent is doing is simply removing the probate the probate claim against the estate, and I'm not then seeing follow up at the death of that spouse against that home. As a practical matter, it's not really possible.
Okay.
So with another exemption would be if the nursing home patient's disabled child or child of age 21 or under is residing at the home,
Okay.
then they will remove the lien.
Okay, and they don't have to be an owner or listed in any way. They just need to be residing there.
Correct.
Okay.
Correct. So if you have a child of any age living at the home who is not disabled, but for a period of 2 years prior to their parents' admission to a nursing home, lived at that home as their primary residence, which doesn't mean stayed there most of the time, which really means was their primary residence, and provided a level of care that essentially kept the parent out of a nursing home for at least 2 years, they will remove the lien. However, you have to have adequate proof of this.
See, this is how our brain, I was just going to ask you, what is the proof you need to prove you live there as a primary residence? Is it a name on a utility bill? What is it?
So that part can be established with things like voter registration, photo ID, utility bills. The more difficult part is, how do you prove the level of care? Because it's not just
Great
being
question.
roommates. You're going to need third-party witness statements, maybe neighbors, friends from your church, healthcare providers who are very familiar with the situation, to be able to give a signed statement basically in support of that.
So while these exemptions exist, this, at least to me, proves why you need to do this proactively.
Absolutely.
Okay.
Because if any of these exemptions do exist at the time the person goes into the nursing home, then it is possible then to transfer ownership at that time without a penalty.
Okay.
Okay. Now, one last point. You can, if the lien that's imposed can't be avoided, it can be reduced dollar for dollar by proven expenses related to the care and maintenance of that home paid for by another person.
Okay.
So
Example?
if mom's in the nursing home, she's spent through all of her money, once she's eligible, her monthly income goes to the nursing home. She gets $50 for her personal needs. Child, let's say daughter, has paid out of her own pocket for 4 years after mom went into the nursing home, taxes, insurance, maintenance, and repairs. She's kept proof of payment and receipt. Then upon sufficient proof of that payment, they will reduce the size of the lien and allow the daughter in this case to get reimbursed dollar for dollar before the state then would collect on its lien.
Okay, what if the lien can be collected and there was still extra money to go to the daughter?
Okay,
It
so
would still be reduced?
and that's so then there's a three-way, there's kind of a three-way benefit in that you're reducing the size of the lien.
Okay.
The lien did exceed the value of the home, and either the daughter with her own funds paid off the lien or the house was sold to satisfy the lien, and then money's left to be divided amongst the heirs. And if in our situation, if the daughter was the sole heir, then she would effectively have the rest of the
Okay.
proceeds from the sale.
All right, so I want to talk a little bit to something you brought up. Anyone can pick up the phone and call pretty much any attorney
Right.
and ask for advice about these situations.
Right.
But it sounds like it's vitally important to call someone with expertise. How do you find, I mean, I would love it if everyone called you, but how do you find a lawyer with this type of expertise?
Sure. So in our state, in the southern part of the state, I'm the only attorney that I know of who has a dedicated elder law practice. This is something that there may be a few attorneys out there that have some knowledge and may be able to provide some assistance. If you want, the wealth of experience that I have, you can contact
Yeah.
my office in Charleston for a consultation. I also have an office in Morgantown as well. So in either of those places, and again, the unique things that I do, clients hire me to help them go through the Medicaid process, qualify for Medicaid, do everything the law allows to save assets last minute, protect their home, whether that's in a last minute setting and or whether that is in a pre-planning setting. There's even another last minute option I didn't have time to talk about called a transfer on death deed. That's a great last minute planning option. It's not an ideal pre-planning option, but if we've got a home and there's been no pre-planning, at least it's something that if the home can be retained through to the end of the senior's life, if they've entered in a nursing home, we can still save it.
Well, and this is why you need an attorney who's worked on these cases. I don't want to say too many years. I mean, I want to give you lots of experience, but he's very young.
18 years.
18 years. So 18 years of experience you really need, because the average person just doesn't know what questions to ask, what options are available. And I think the most vital thing I'd like to encourage our viewers to do is when looking for an attorney to deal with these issues, it sounds like you need to ask, do you specialize in elder care law? Because it sounds like there are not a lot of attorneys in West Virginia who do what you do.
In the southern part of the state, that's right.
Okay.
Now there are in some of the other counties, especially in the northern, eastern, and western portions of the state, central western portions of the state, but in the southern part of the state, there were 2 attorneys doing this. One retired due to a severe disability. The other one died unexpectedly of a heart attack. So that prompted me to open a second office down here in Charleston many years ago.
Well, perfect. We're glad you're around to help everybody, and we're really
Thank you.
grateful to all of you for watching tonight. And again, we just encourage you when you have to deal with these issues to make sure you're talking to the correct person. And we're going to follow up with more episodes and more topics. We thank you all for joining us.
Hi, I'm Brent Van Dyson. As an elder law attorney, my law firm can help you protect your assets from the high cost of nursing home care. In your community, we will soon be having free legal seminars where you can come and learn more about the options available to protect your home and your life savings from the high cost of nursing home care. Watch your local newspaper for advertisements of this event, or visit our website at wvelderlaw.com for a list of the upcoming seminars.